what assignment you have to make? The leading schemes of Government of India for MSME sector. So see, I have a clear-cut plan for you. I will do certain things in my class. Fine, I will do certain things in my class. Certain things I will provide in the PDF. Fine. Certain things I am going to ask you to do. So the task which I am going to ask you to do, fine, that is simple copy and paste task, where you need not to put your understanding or something like that. Just read, copy and paste and collect at one place. That is going to be your work. My work will be discuss important topics in the class, and those topics which are not very important, I will not very important to discuss in the class. That topic I will provide in the PDF form. Fine. Though I have not provided last week's PDF, so last week's PDF and this week's PDF, one compilation I'll provide you. Fine. So in that compilation, you are going to get the important details. Fine. I'm extremely sorry. Last week I forgot about to prepare the PDF, but I have scheduled it. So this week onwards, you are not going to face the difficulty. Last week, fine. So in nutshell, from June 1st to June 15th. So June 1st to June 15th, 15 days compilation of the important topics I'll provide. But remember that you have not to be collector who is collecting the material. The bad habit of the UPSC aspirant is being a collector. UPSC civil service वाला collector नहीं, collector of the material. ये material, वो material, PDF material, book material, lot of material. Are you collecting or not? Not? No, not possible. That is going to give an immense pleasure. Wow, I have this collection, books collection, all these books collection, all the polity book. Majority of the students, and sometimes they will come, sir, I got the latest edition of this book. Do you want? हाँ भेज दो, मेरे को भी भेज दो, क्योंकि मुझे भी अच्छा लगता है collection. But I also go for reading of those collection. Fine. So please do not unnecessarily be a collector only. Fine. So this is very dangerous, because what happened when you collect that thing, you will get a sense of achievement. Ki I have it. But having it is not going to work until unless you are going to read it. Fine. So just not be a collector. What PDF or what material you have, please read it thoroughly and properly. Fine. Now let's start the important news of this week. And most important news is regarding to the expansion of the number of vacancies in the Supreme Court. So give a heading there. Appointment and increase in the vacancies of Supreme Court. So here we will not deal with how the vacancies are being increased. We will deal with how the judges are appointed. So heading is appointment and increase in the vacancies of Supreme Court. Then give a subheading, constitutional basis. Constitutional basis. First heading is constitutional basis for appointment of judges. Remember that whenever anything in the news, fine. So anything is in the news. So how UPSC will go for it? UPSC is not looking only the text. They will add with the context. Context. Till the last year, context is related to that subject only. Means something which is in the news and related to polity, they will frame the question in the field of polity only. But now what they are doing? They are seeing the topic and they are seeing that this topic can be connected with any related thing also. So for example, government have formulated a policy. Fine. So how that policy, which is basically for MP and MLAs, or suppose that any particular sector, what will be the impact on overall society? Fine. What will be the impact on the society? What will be the impact on economy? So they are going for one topic from polity, but they will connect with what? Maybe they will connect with the economy. So you have to go for broader context of any news which is coming in the newspaper. For example, right here, the news is related to what? number of increase in the vacancies in the Supreme Court. But how the judges are being appointed, first we will deal that. Right, point number 1. Article 124 deals with establishment and composition of Supreme Court. Composition of Supreme Court and appointment of judges. Appointment of judges. Second point, the detailed step-by-step procedure. The detailed step-by-step procedure to appoint judges. Is laid down in the memorandum of procedure. In the memorandum of procedure, MOP, capital M, small o, capital P, memorandum of procedure, framed after second judge's case, in brackets 1993, second judge's case 1993, and third judge's case / presidential reference in brackets 1998. Now see, according to Constitution, Article 124 Clause 2. So Article 124 Clause 2 explicitly says that. I'll make you write. Just listen. Understand first. Article 124 Clause 2 clearly says that. I'll read it for you. It says that the President appoints judges after consultation with the judges of Supreme Court and High Court as deemed necessary. So appointment of the judges will be done by whom? President. Within consultation with whom? Judges of Supreme Court and High Court as deemed necessary. Fine. So the idea is, when Supreme Court judges are going to be appointed, judges of the Supreme Court will be consulted by whom? President. So President will consult whom? The judges of the Supreme Court, and then they are going to appoint the judge. Now the question of consultation works how? So if we will see from the independence, the consultation process work, it's a basically executive decision. You will be asked, shall we appoint this person or not? So either you can say yes, or you can say no, or you can say I don't want to make my statement on this matter. So President asked, we want to appoint some people in the Supreme Court as a judge. What is your opinion? To whom I should appoint? So you have given your view, and that is called consultation. After your view, it is up to President whether he is going to accept or he can reject. So this is the process up to 1980s. But when judiciary got hurt, when Justice H.R. Khanna, fine, he have given a against judgment against Indira Gandhi. So he has given the judgment against the Indira Gandhi, and he was supposed to be the next Chief Justice. Because in India, there is a system that the senior most judge of the Supreme Court is going to be appointed as a next Chief Justice, CJI. But that system was broken. Justice Baig was being appointed as a Chief Justice of Supreme Court, though he was in the third in the hierarchy. Fine. So H.R. Khanna have resigned. He resigned. And since then, judiciary will come to this thing in the mind that there is unnecessary interference by whom? Unnecessary interference by executive. Now, how the mindset works? If I will interfere in your work, fine. then the first thing in coming in your mind is, if I am not you, fine, if I am interfering in your work, how you will think? If I am not interfering in his work, why he is interfering in my work? So when people work in the workplace, fine. So when you are going to interfere in other person's work, fine. So other person's first thought will be, why he is interfering in my work if I'm not interfering in his work? So this is an idea got developed in the mind of judiciary, and judiciary have decided we have to do something. Fine, we have to do something. So judges himself take this case suo motu. Fine, and they started discussing on this matter, and they decided the consultation of who? Judiciary. Fine, the consultation of judiciary under Article 124(2) is not just a consultation. President have to accept the advice. Judges will be appointed only on the advice, not by the executive arbitrary action, and that advice or consultation is mandatory in the nature, and the advice of Chief Justice will matter. Fine. So this is a kind of a judgment given by the Supreme Court. Then Supreme Court further evaluated his own judgment and found that only Chief Justice should not be there, senior most judge should be there. Then again, the senior most judge will be added by one more senior most judge. So that have created a collegium. Collegium means CJI and 3 senior most judges. So total 4 people will be there, and they will assess, they will give advice to whom? President. Fine. And President accordingly going to appoint. Fine. Then President also sent a questions to whom? Supreme Court regarding this appointment. So President wants certain clarification. So President want the clarification, basic clarification want by the President in 1988. If I do not want to appoint that person, then what? I do not want to appoint that person. This is basic question framed by the President and asked to the Supreme Court. So Supreme Court have answered this question. Supreme Court said that if you have any reservation with respect to the appointment of that judge, then you have to send it back with the reasons. You have to send back the name with the reasons and explanation why executives do not want to appoint that judge. Fine. Why executive is having certain reservation for appointment of that person as a judge. Send it. After you will send, we will see that. And if we will found your reason, logic, explanation well enough, we will withdraw the name. But if your reason and logic is arbitrary and not acceptable to the collegium, then we will revert that name back to your executive, and then executive do not have any option but to appoint the person as a judge. So 1998 presidential reference and third judge's case have cleared who can be final authority to appoint the judge. Means now who can be the judge of the Supreme Court is decided by whom? Collegium. And here one issue started coming, brother judge syndrome. Brother judge syndrome means I am having sympathy with you. Fine. So if I gain the sympathy with you, I will try to make you also a judge of the Supreme Court. So that brother judge syndrome may act. So this is why government want to impose NCJC. But again what happened? National Judicial Council Act was passed by the Parliament, but again Supreme Court have struck it down. Supreme Court have made it clear that no interference of executive in the appointment of judges of the Supreme Court. This is crystal clear by whom? Supreme Court. Though this judgment of the Supreme Court is one of the most criticized judgment in the recent years. Though multiple judgments of the Supreme Court is being criticized. And remember that you can criticize the judgment. You cannot target the judge. You can question the judgment. anywhere, any platform, you can question the judgment, but your question should not be defamatory in the nature. Your question should not be targeting a person who has given the judgment. Judgments are always open for criticism. In fact, Supreme Court multiple times they change their own judgment. 3 judges bench case is being taken, judgment is being given, and it is overturned by 5 judges bench. 2 judges bench have given the order where they have restricted the power of president and governor with respect to the assent of the bill. Then again, 5 judges bench have changed this. So any decision by the Supreme Court can be criticized. We are in the democracy, fine, democracy, and here democracy allow us to criticize the judgment but not targeting the individual. So NCJC judgment of the Supreme Court, National Judicial Council Act case, was one of the most criticized judgment. Even all the existing judges and those judges who are going to retire, and whenever they will appear in for any interview, this question is being asked to them. Sir, do you feel that Supreme Court was not right when they have passed the judgment of NCJC? So this question is one of the widely used judgment. So my job is what? I will provide you NCJC document. What happened? What was the NCJC? Why it came into the picture? And why ultimately Supreme Court have rejected? And why this is an open debate in the Indian democracy as of right now? Though again, the possibility of the question in general is very less. But if the debate will be triggered, because as I said that it's a hotly debated topic, fine, there is a debate on this topic even among the judges also. Certain judges want NCJC, fine, but many of the judges do not want NCJC. So even judiciary is not one side ki NCJC is wrong. Certain Supreme Court judges, they have favored for the NCJC. So it is a debated topic, and maybe some point of time it will again flare up. So once it will be flare up against, there is a strong possibility of what? The question can be framed. So what I am going to do, in what context NCJC came, what are the main provisions of the NCJC, why Supreme Court have put the reservation on that, criticism of those reservation, and way forward I'll provide you. Your job is to read it and have it. And again, this is not something which cannot be done by even a beginner. Fine. So those who are just starting their journey in the civil services, all the students who are listening me online first time, they are attending any lecture, for them also. See, at some point of time you have to start. Fine. At some point of time to start. So even you are a beginner, you do not have any idea of that topic. So let's go into that, try to uncover the topic. Do not wait for the right moment. There is always a right moment when you start. कोई मुहूर्त नहीं निकलना है. No need to find the right muhurat. Ki on this day, on this auspicious occasion, and by sitting in this direction and doing this work, I'll start. Anywhere, anytime you can start. Okay? So NCJC, I will provide as a PDF document. Okay? Now write one more point. Next point. The same text which I have explained. The text to the Article 124 Clause 2. The text to Article 124 Clause 2 is the President appoints Supreme Court judges. The President appoints Supreme Court judges after consultation with judges of Supreme Court. After consultation of judges of Supreme Court and High Court. High Court. Fine. High Court, when the High Court judge's appointment will be there, then High Court judge. Otherwise, Supreme Court judge for who? Supreme Court judges. Now write further. Supreme Court and High Court as deemed necessary. As deemed necessary. However, here underline that word after consultation. Underline the word after consultation. Underline that word. Then write after second and third judges cases. After second and third judges case, this consultation has been interpreted to mean that primacy lies with judiciary. Primacy lies with judiciary through collegium. Right, further in the same point, the executive formally appoints. But cannot override. Collegium's recommendation. Write a note, collegium is equal to CJI plus 4 senior most judge. I think I said 3, but it is CJI plus 4 senior most judge forms collegium. Fine. Now write next point. You can give subheading, step-by-step process of appointment of judges. Step-by-step process for appointment of judges. Tell me one thing, if this statement will come in the exam. The statement says that according to Article 124 Clause 2, the appointment of judges is made by President after consultation of judges of the Supreme Court. This statement is going to be true or false? If consider the following statement. See, the question is, consider the following statement. Statement number 1. It says that the appointment of judges in India is done by a president after consultation of judges of the Supreme Court. Statement number 1. Statement number 2 is saying that the vacancies of the judges in the Supreme Court is fixed by the Parliament. That statement is true. It is fixed by the Parliament, not by the Constitution itself. It is fixed by the Parliament. Second statement is true. But first statement is true. The first statement is true or false? Bolo? True or false? First statement. First statement is true or false? अरे बोलो ना, मुंह में फेविकोल लगा है क्या? आंसर बोलो. True or false? How many are feeling that it's true? Raise a hand. True. तुम हाथ ऊपर कर रहे हो कि तुम हाई कर रहे हो? True or false? True. Rest of the people feels false. Statement is perfectly correct. It is true statement. Interpretation is being changed. Article is not being changed, na? It is still mentioned in Article 124 Clause 2. Statement is still mentioned in the Constitution. There is no change in the statement. Only what changed? The interpretation of the term after consultation. See what they have changed. They have changed the interpretation. Text is still there and perfectly correct. This is how UPSC play with you. उनको पता है कि आप यहाँ पे मिस्टेक करोगे. Fine. So remember that exam is not about your subject knowledge only. How you are good in the logical reasoning, not in the CSAT, but how you are good in the logical reasoning based decision making. So that is not going to test only in the CSAT. It is going to be tested here also. Fine. So the text is perfectly correct. There is nothing wrong in that text. Text is correct. Only what change? Its interpretation change. Now, if they will add one more statement, and they will say that though the statement says that it will be appointed by the president after consultation of the judges. However, this is only a statement. However, this is only a customary in the nature. Majority or not majority, all the appointments are being made only through collegium system. So the first statement they have mentioned. Fine. What they have mentioned? President appoints the judges of the Supreme Court after consultation of the judges of the Supreme Court. Fine. This is the first statement. Second statement, number of vacancies decided by the Parliament. And now to put ultimate confusion in your mind, they have mentioned ki usually not usually even, Supreme Court judges as per present practice, Supreme Court judges are being appointed on the dictates of collegium system where executive do not have any power. Now, if you are in the examination hall and you will see the statement number 1 and statement number 3, you will feel that statement number 3 is correct and statement number 1 is incorrect. But both statements are correct. In fact, in this question, all 3 statements are correct. Why? Article 124 clause 2 have clearly mentioned. What have changed? Only interpretation is being changed. And the statement number 3 is mentioning about that interpretation. Fine. So they will try to confuse you in the basic understanding only. They are not going to ask too many hi-fi questions. And people will slip in this simple interpretation only. Fine. So remember that Article 124 clause 2 is still valid. Only what changed? The word consultation's meaning is being changed. The meaning of the word consultation is being reinterpreted by whom? Judiciary through what? Second and third judges case. The question can be framed in this way also. First statement, Supreme Court judges are being appointed under Article 124 clause 2, which read as President will appoint the judges of the Supreme Court after consultation of Supreme Court judges. Fine. Statement number 2, the vacancies of the Supreme Court is decided by the Parliament through law, parliamentary law, not through the amendment to the Constitution. This second statement. Third statement is saying that while making an appointments of the judges of the Supreme Court, the consultation is explained as a collegium system of the Supreme Court under first judges case. So first judges case have not talked about collegium system. The second and the third judges case have talked about collegium system. First judges case only whom? CJI. In the first judges case, the result came CJI. In the second and third judges case, they came with the idea of collegium system. So clarity is required. The text should be crystal clear in your mind. No confusion, no doubts. And this is why the good information repeated multiple times is going to give you a wider understanding. Understood? Now write there, step-by-step process. As per MOP. As per MOP. What is MOP? Yes. As per MOP, proposal for appointments of judges. Proposal for appointment of judges of Supreme Court is initiated by CJI. Initiated by CJI, Chief Justice of India. Initiated by CJI, Chief Justice of India. Next point. A candidate can be Chief Justice or Judges of High Court. A candidate can be Chief Justice, or Judges of High Court. Number 2, eminent member of Bar Council. eminent members of bar council. Fine. Third, distinguished jurist. Distinguished jurist. As expressly distinguished jurist, as expressly mentioned in Article 124, Clause 3. Clause 3. Now, question is, who is distinguished jurist? So basically, if you are existing judge in the High Court or Chief Justice of a High Court, you are eligible to be appointed as judge in the Supreme Court. Number one. If you are an advocate in the Supreme Court and you have at least 10 years of experience, fine, then you are also eligible. And third is you are distinguished jurist. So now write, who is distinguished jurist? Distinguished jurist, right? Who is distinguished jurist? Fine. Ab likho mazedar point, interesting point. The Constitution do not define distinguished jurist. The Constitution does not define distinguished jurist. A legal scholar or academic, a legal scholar or academic of outstanding reputation. Outstanding reputation. Or a legal expert with significant intellectual contribution to law through path-breaking books, committees, international law work. Fine. So if you want to become a Supreme Court judge, write certain good book where you are going to explain about law, and Supreme Court judges are going to be mesmerized by your work and they are going to use your work for their understanding about the law. Then you will be also eligible under Article 124, Clause 3, Subclause C. Fine. Clause 3, Subclause C, you can be also eligible to become a Supreme Court judge. Okay? So after becoming an IAS officer, you should start having the knowledge of law and then write some book, and that book must be impress whom? Judges of the Supreme Court. Compel them. No. Now we have to change our stance. Now we have to appoint this person as a judge. But the fact of matter is, no one ever have appointed as an eminent jurist, as a judge of the Supreme Court. Never any appointment happened as an eminent jurist. Okay? So this thing you should keep in the mind. Who is an eminent jurist? Eminent jurist means basically a person who have good knowledge in the law, and good knowledge, the proven knowledge. Proven knowledge means his work is properly acknowledged in the field of law. And how it is acknowledged? Through his book, through his consultation, through his work in the international law or domestic law. Fine. So in that way, you can be. So there are many people who are having good sound knowledge in the law, especially those who are teaching at National Law University. NLUs. Fine. So National Law University, there are multiple professors who are teaching in the law. So basically the idea is, who can be judge? An existing judge can be judge of the Supreme Court, or any existing lawyer can be the judge of the Supreme Court. But what about the academicians? So those academicians who are having the academic knowledge of the law, they can also be a judge. But irony is only those who are already judge or they are already a lawyer are being appointed as a judge in India till then date. No eminent jurist is being ever appointed as a judge of the Supreme Court. Once you will appoint an eminent jurist, now the path will be open for many others to be appointed as a judge of the Supreme Court. Understood the eminent jurist? Now write further. The Supreme Court Collegium, next point, the Supreme Court Collegium considers the name and passes a resolution. Considers the names and passes a resolution recommending specific candidate. Recommending specific candidate. If a candidate is from particular high court, if the candidate is from a particular high court, the collegium also consult. The collegium also consult the senior most Supreme Court judge. The senior most Supreme Court judge who originally from that high court. Who originally from that high court as per MOP. As per MOP. That means what? That means only collegium decides? Yes, collegium decides. But collegium can take a consultation of that Supreme Court judge. Fine. So suppose that Telangana High Court. So Supreme Court is considering a judge from Telangana High Court can be appointed as a judge of Supreme Court. So while collegium is going to take the name of Telangana High Court judge, Supreme Court can ask any judge who is from which court? Telangana High Court, and he is already judge at where? Supreme Court. So suppose three judges are originally from where? Telangana High Court, and they are at present whom? Judge in the Supreme Court. Three judges are already in the Supreme Court and they are from what? Telangana High Court. Now, Supreme Court Collegium will ask among three who is the senior most. Whosoever is the senior most. So, suppose there are three judges A, B and C. They are from what? Telangana High Court. Fine? Telangana High Court. So, among these three, suppose B is the senior most. Then collegium will ask this person to provide your opinion about that candidate of whom we are thinking about to appoint as a judge in the Supreme Court. So this point is important point. Usually it is not mentioned in what? Usually it is not mentioned in the textbooks. So this point is important. You should keep with your point. Okay. Right further. Collegium. Next point. Collegium recommends. Collegium recommendations. Collegium recommendations are sent to Union Law Ministry. Union Law Ministry, which processes the file and forward it to PM. Forward it to PM. And the PM advises President to appoint, and Prime Minister advises the President to appoint the recommended person, as a Supreme Court judge. As a Supreme Court judge. Next point. However, if government is not satisfied with the name, they can return the name. they can return the name for reconsideration. This act of the government usually pointing out adverse inputs, IB report. IB stand for Intelligence Bureau. IB report or other concerns. Fine. So, if government is not satisfied with the name of Justice 𝐾𝐸 Joseph, fine, then Supreme Court will be asked, means name will be returned. The name will be returned and you can mention certain concerns. So, if your concerns are valid, maybe Supreme Court is going to accept and they will drop the name. But if your concerns are not valid, then what Supreme Court will do? Right. If collegium after reconsideration, send back the name again. Government is constitutionally bound. To make appointment. Government is constitutionally bound to make the appointment. Fine. So this is the process how the judge will appoint. Now give a heading: process to increase number of judges. Process to increase number of judges in the Supreme Court. Right. Point number 1. Article 124 clause 1. Article 124 clause 1 says, Article 124 clause 1 says, Supreme Court shall consist of. Supreme Court shall consist of CJI, and such number of other judges, as Parliament may by law prescribe. Parliament may by law prescribe. Thus, Parliament has the power to increase or decrease the strength of Supreme Court judges by law. Supreme Court judges by law, not by executive order, or constitutional amendment, or judiciary on their own. So constitutional amendment is required? No. Executive can do on its own? Answer is no. Who can do that? Parliament by law. Parliament by resolution? No. Resolution is not enough. You have to pass a law. So what is the difference between resolution and law? Law is going to be properly presented in the form of bill and it is going to be passed by both house. Whereas Parliament have took the resolution. So resolution is a kind of a showing their will. Okay, this is our will. Parliament have passed a resolution and condemning the attack on Iran. Suppose. So India's Parliament is going to do this. So this is going to be very important. Why very important? Because Parliament is representing whom? Whom? 1.52 billion people. So when Parliament passes a resolution, so it is not just a resolution, it is a will of 1.52 billion people of India. So when Parliament says something at international level, so imagine, just imagine, if Indian Parliament have passed a resolution and they have condemned the attack on Iran. So this is official view of India. We are not okay with the attack on whom? Iran. Pahalgam attack happened, Parliament passed the resolution. Fine. Some disaster happened and that need to be rectified, Parliament can pass the resolution. So parliamentary resolutions, especially in the context of international law, they provide a pressure. So question is being asked, can Parliament play a role in the foreign policy? Answer is yes, through the resolutions. So Parliament can pass a resolution and through those resolutions, they can give their view about the foreign policy. Usually it happens when a coalition government is there. Fine. Coalition government is there. So coalition government is there. Certain coalition partners are not okay. Certain coalition partners are not okay, but they are giving support to government's law. But they are not okay. So they can send a caution to the government through parliamentary resolution. For example, when India and USA have signed a Indo-US nuclear deal back in 2005. Back in 2005, they have went for Indo-US nuclear deal. At that time, Communist Party of India, they are supporting UPA government. Communist Party of India was not okay with that. But they followed the coalition dharma and they said that, okay, we will support the bill presented by the government in the parliament. We'll support the bill. And ultimately, they have supported. But they again pushed the government to bring a resolution. And resolution should put what? Resolution should put in the parliament and that resolution should be passed and show the concern of the parliament. Though we are passing this law, but we are having the concern. So parliamentary resolutions are also important. And if any resolution is going to be passed, from here, be attentive, be focused. If parliament is going to pass any resolution, that is an immense important topic. Question can be framed in the prelims, question can be framed in the mains, question can be asked even in the interview regarding that resolution taken by the parliament. So you should have complete knowledge of any recently passed parliamentary resolution. Okay? तो वहां पे note करके लिख लो. You can write it there. Parliamentary resolutions are important as they show will of the parliament. As they show will of the parliament. Hence, such topic on which resolution is passed should be dealt in detail. Should be dealt in detail. Fine. So all details you have to gather. Don't take it lightly or casually. If any parliamentary resolution is there, they are important topic for your preparation. Fine. Right. Next point. The present sanctioned strength. The present sanctioned strength is fixed under Supreme Court, fixed under Supreme Court, in brackets, number of judges, in brackets, number of judges, bracket close, Act 1956. 1956. Fine. Write the next point. Parliament has amended this Act multiple times. Gradually increasing judges from judges from 8 in brackets including CJI. Judges from 8 including CJI in 1950. 8 including CJI bracket close 1950 to higher numbers through amendments in through amendments in 1956, amendments in 1956, 1960, 1978, 1986, 2009, 2019, now 2026. What is the number of judges in Supreme Court right now after this change? 38, including CJI or excluding CJI? Including CJI. So in 2026, now after the change, how many judges? Total 38 judges, 37 plus 1. Fine? 37 plus 1. CJI plus 37 judges. But if you see multiple reports, fine, the number of pendency of the cases in India, if you will go by that, minimum 100 judges are required. If you want to solve all pending cases in next 20 years. So the number of cases which are pending in the Supreme Court, if you want to solve those cases in next 20 years, minimum 100 judges are required. Fine. So this is a sorrow case of India's judiciary, where judicial infrastructure is still very weak. When I say judicial infrastructure is weak, the number of judges, the facilities in the court, and the functioning of the judicial system. So multiple times this question comes in the picture. The question of justice delayed is justice denied. And justice delayed is not because judges are taking their time, because the number of judges are very low and judiciary is actually facing this crisis. Fine. Same problem of the police infrastructure in India. Fine. So people are not following the law. Many times we have seen that petty crimes, lot of criminal activities are happening. Not because people are criminal minded. We do not have sufficient number of the police people in our country. So the police reforms, okay, the police reforms and the judicial reforms. So judicial reforms just not only focus on appointment of the judges. Usually when this question is being asked, judicial reforms, so the attention of a person only goes to how the judges being appointed. Judicial reforms are not only the case of how the judges are being appointed. Judicial reforms also include reforms in judicial infrastructure. Justice delays is justice denied is said because existing law. So for example, government came with the BNS, Bharatiya Nyaya Sanhita, fine, Bharatiya Danda Sanhita. So the purpose is what? The purpose is to remove all those outdated laws which are unnecessarily dragging certain things. So outdated laws must be removed and the law should be changed according to the present need and requirement. One aspect. Number two, the most important aspect is judicial infrastructure. Fine, the judicial infrastructure in the country. You can take this and you can collect the data on this matter. You can collect this data in this way, or don't do that. I'll provide. Listen, just write those points and give me after the class. So I will prepare the material and I'll provide you the entire class. Fine. So how many judges we do have? How many police personnel we do have? Fine. Among the population. Such data is very precious data when you are going to write on what? Police reforms and judicial reforms. So when we talk about police reforms, judicial reforms, such reforms need a structural changes also. Because the number of vacancies we do have in the judiciary, the number of vacancies we do have in the police forces, if that is going to be accepted, Next year, you are going to have at least 500 vacancies for IPS only. IPS का ही 500 vacancy होगा. If government is going to accept and going for the changes, fine, and at least 1 lakh sub-inspectors, fine, 3 lakh, minimum 3 lakh additional constables are required. Minimum, I am saying the minimum. अभी ये minimum से भी नीचे है. Fine. So when a country become prosperous, fine. So country become prosperous, country's ability is to have more workforce also increases. So developed countries are developed country. They do not have a crime. Yes, they do have a crime. But why those countries have a less crime in comparison to countries like developing countries like India? The reason is the robust system of law enforcement agencies. How the robust system is there? The robust system is like they are having more number of police personnel who can go for patrolling consistent basis. The process is better where the law is going to provide speedy justice. Fine. So law enforcement agency is sufficiently having the human resource. Similarly, judiciary is also having sufficient amount of human resource. And that is why law enforcement agencies and the judicial system works in much better manner how they work in India. So we are not people who are bad in comparison to the people of the developed country. Actually, system have certain inherent issues. To have more number of people, you have to bear the cost. Fine, you have to bear the cost. And when you start able to bearing the cost, for example, one more example. Usually it is said that India is not able to perform very well in sports, especially at Olympic level sports. कहाँ से करोगे performance भाई? For that level of performance, you have to need to be proper trained your athletes. I was doing one study, fine, regarding health issues, fine. So health related issues. I told this thing in one class also. One of my family person, like one kid who's looking for the sports. He want to go in the sports. So he said that ki, Chachu, what creatine I should take? Fine. So I said if you want to go for proper athlete and you are concerned ki you will be not in the dope test, then you should purchase a creatine which is costing somewhere around 6,000 rupees. Only 250 gram. For your consideration, those people who do not know about the creatine, that creatine of 250 gram usually come in the Indian market somewhere around 600 rupees to 1200 rupees to 1400 rupees. And same creatine is going to cost at athlete level going to be 5,000 to 6,000 rupees. Why? Because it is not being produced in India. You have to purchase it from USA. Why it is costly? It is having some special ingredients? Answer is no. Same creatine. But that company which is producing that creatine, it is certifying that our creatine do not have any heavy metals. Because if you are using a creatine for increasing your performance and the company which is providing the creatine to you, if they are using any heavy metals and it will be found in the dope test, you will be banned. So Virat Kohli uses that creatine. If he uses creatine of that company. Majority of the athletes of the world who are performing at national level, international level, they use that company's creatine. Only why? Because that company produced that creatine in the batches only, small batches. And every batch is going to be properly certified. Until unless the certification company is not going to certify if this creatine is clean, they will not release the batch. So suppose I have manufactured 10,000 units. So out of 10,000 units, randomly 100 units will go for testing. And once the testing is being cleared, only then that batch will be put forward for what purpose? Selling purpose. So this is a strict protocol to sell the creatine. Cheapest. It is considered the cheapest source of what? Protein. Now imagine you have to have such level of accuracy. Majority of the athletes in India, they are even not able to afford 800 rupees creatine, which is 250 grams. So imagine how they will afford that. The kind of diet, the kind of practice. Recently, games were happening in Delhi. Fine. And do you know that the pole vault guy who's playing for the pole vault, after game is over, he booked a tuk-tuk. See, this is the sort of state of the sports in India. He hired a tuk-tuk like battery rickshaw. And in that battery rickshaw, he have took his pole vault. Means our sports authorities are not sufficiently having the resources to provide all these facilities. Whereas in the USA, government is going to ensure the pool temperature. So pool temperature should be 34 degree, exact 34 degree. So they will invest heavily so that the pool temperature shall be only 34 degree, not even low by even 1 degree. So 34 degree is going to be maintained. Why? Because it's a Olympic standard. So sports again need what? Again need lot of money. And I always say that to reach the moon is a matter of economics, not physics. And that is not only to the moon. To perform, to achieve, to correct, to modify, to upgrade, everywhere what is required? The money is required. And this is why you can see the China. How China has transformed. Why? Because they have a billions of the dollar to spend in the system. They have created sports university in year 2000. Spending $2 billion. $2 billion they have spent for what? Creation of sports university. Government of India have also given the idea to establish sports university. And the budget was total of 10 crore rupees. 10 crore rupees. And if you go by $2 billion in 2000, in year 2000 in Indian rupees, right? So not 8,000, in Indian rupees in year 2000, it will be somewhere around 10,000 crores. So in 2000, China spent 10,000 crore to create a sports university. Government of India in recent year, they have spent how much? 4 crore rupees to establish a sports university. It is not the government of India is not having the vision. Government of India having the vision. But we have to spend money on multiple things. Malnutrition, provide the basic education, multiple subsidies, all these things. So money get very less. So the blamish approach should not be there. So usually student, while writing an answer, they will put a blame on the government of India. Government of India is not paying attention. Government of India do not have a sufficient resources. So resource allocation, resource management and increasing the resource to invest in certain things so that our system, whether the sports or it's a police infrastructure or it's a judicial infrastructure, need to be improved. समझ में आया मेरा बात आपको? What to do when you are handling such questions? Fine. So now we have finished this part. Right, next point. Important judgment given by the Supreme Court, and this important judgment is related to one specific case. What happened? People are traveling, fine, and during this travel, a car met with the accident, and in that accident, husband and wife both died, fine. So now, if the accident happened, basically you can go to the tribunal and demand for compensation. So while demanding a compensation, a tribunal have awarded compensation for the death of the man because he is a bread earner. But when the family demanded the compensation for the lady who have died, the tribunal have refused. They went to the High Court. High Court also refused. Then they went to the Supreme Court. And here Supreme Court have given the landmark judgment. Supreme Court said that even a wife, she is a homemaker, she do not have any source of income, still for her loss, the family should be compensated minimum 30,000 rupees per month. Minimum 30,000 rupees per month should be compensated to the family whose homemaker is died. And Supreme Court have used very specific word, homemaker as a national builder. So homemakers are not homemaker. They are nation builder. Why? Because they are unpaid work. Like many of you, including me, have mother who is working in house without any payment. And usually we call it as a homemaker. So even in the interview, you are going to fill your detailed application form. If your mother is not working, you are going to write what? Homemaker. So homemaker lady is not just a homemaker. She is not homemaker only. She is a nation builder. Why? Because she is giving her immense time and work, and that allows the husband to go outside and earn. Fine. Till then now, this homemaker's ability is usually used in the compensation while the divorce cases. Fine. But now Supreme Court says that even the tribunals who are taking this decision, they have to consider if any woman who is homemaker, she is going to die or having permanent disability due to the accident, then tribunal who is providing the award while considering the compensation, they should take minimum how much? 30,000. So now the case of care economy emerged. Care economy, where the person is not getting proper monetary benefits against the service, but their service is not zero. Their service are very important. 2 years back, UPSC have asked a question on care economy. Fine. So this judgment again triggered the debate on care economy. Fine. Again, what is care economy? How it works? I will provide the document. I will provide the document how care economy works. I will provide. But the judgment which is given by the Supreme Court, please write it in short. Right. The 2 judges bench of the Supreme Court delivered a landmark judgment and described homemaker as a nation builder. Homemaker as a nation builder. And created a new and independent head of compensation. New and independent head of compensation called loss of domestic care. Underline this, loss of domestic care. In motor accident claims, where the homemaker dies. Next point. It directed motor accident claim tribunal. MACT. Motor Accident Claim Tribunal, MACT, to treat the value of domestic care. As minimum 30,000. Per month. Where the homemaker had no formal monetary income. And this should be revised upwards. By 10% every 3 years. Revised upwards by 10% every 3 years. Fine. Now write about MACT, Motor Accident Claim Tribunal. Right. MACT is a special tribunal. Under section 165. Under section 165 of Motor Vehicle Act 1988. To decide compensation claims. to decide compensation claims arising from motor vehicle accidents. Arising from motor vehicle accidents. One more point. MACT exists at district level and usually presided over by a district judge or additional district judge, rank judicial officer. Additional district judge, rank judicial officer, functioning within district judiciary. District judiciary with specialized jurisdiction. Okay. Next is algorithmic justice. Next topic is algorithmic justice. Next topic. Fine. Next topic is algorithmic justice. So do you know who is algorithmic justice? Algorithm जानते हो? Algorithm? हाँ? Do you have any algorithm? Huh? First come, first serve. That is algorithm. First come, first serve. It's algorithm. When you woke up at midnight for some reason, you may know that. I don't know that. Or you woke up in the morning. The first thing what you do, even your eyes are not properly open. Fine. And if your phone is not getting on, then you will not do anything, but you will first put your phone in the charging. Fine. The moment you saw that the battery is showing red signal, phone battery, immediately you will do what? Charge. And if power is not there, your heart is about to fail. What will happen if my phone is going to be switched off? Okay? Do one thing. Switch off your phone for 10 minutes and see how much you are going to be worried about the phone. Maybe he will call, she will call, this will happen, that will happen, nuclear attack will happen, how I will survive myself. All these things will happen. So algorithm is what? A step-by-step process where you can guess what next is going to happen or what next to be done in a simple layman language. So this is the next logical step after this step. This is the next logical step after this step. So the first logical step for you when you woke up, the first logical step is open the phone and check the calls and messages. Though it should not be done, especially in the morning, unless your eyes are not properly open, you should not touch the phone. But people will do that thing. Fine. Even certain people will always put the hand in the range of half meter. Fine. Half meter means it should be in that. Since certain people start doing this, fine. काम गया, ठीक है? इधर 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 किधर है? Fine. That should not be done. But people will do that. So you have created the algorithm for you. Fine. A newly born baby, 6 months or 1 year or 1.5 years, it becomes toddler. Now the toddler's food habit is highly linked with phone. Some sort of music or video is required. Fine. So that kid have learned that food will be inside the body only when YouTube video will be played. So he do not know what YouTube is, but he recognizes the icon. आप try करके देखना. आप phone को unlock करके दे दो, automatically swipe this, they will find the YouTube, they will play the video. and they will also learn how to disconnect the calls. Fine, तुमको समझ में आ जाएगा. If the green button is being pressed, video will be vanished. So keep pressing what? Red button. Ensure you are going to enjoy your video, and they will also understand this means play. Fine. So this is not a formal learning. It's an algorithmic learning. Step by step, they understood. First, start crying loudly so that everyone is going to be scared. Fine, and cry loudly. And if you are going to see more people, cry more loudly. Fine. If at home you cannot cry because these people are going to beat. Fine, but if it outside, they will not beat because बच्चों को पिटाई नहीं करते. So they learn this habit. Algorithms. These are the algorithms which they have learned. Fine, and they will do that thing in the systematic manner. So this algorithm is a basis for going for generative AI. So generative AI works on the machine learning system, and this machine learning system can create the models which is called as generative AI model. Fine. So now this generative AI model is trying to create algorithm for every area. Fine. The best example for algorithm right now, if you are using any social media platform, especially Instagram, fine. So what will happen? You scroll something and you find some advertisement, and by mistake you have touched that advertisement. Now Instagram says yes. Okay? Now they are going to show you that advertisement multiple times. Fine? Algorithm. So these algorithms are very common in the social media platform. Fine? Multiple platforms. Now these algorithms are also coming in the court. Many of the judicial officers, what they are doing? They are drafting the entire case through the help of AI. Many lawyers, judicial officers, they have started framing the entire frame on the basis of algorithm. So what you have did, suppose that certain judgments are given by the Supreme Court or High Court, you have picked all those judgments and you put those judgments to whom? AI. AI learned from those judgments. In this case, this judgment was given by the Supreme Court. If this will happen, Supreme Court has given this judgment. In this case, Supreme Court have this judgment. Now you do not have my lord in the courtroom. Now the my lord is replaced by my AI. So AI is going to listen your case, and after listening your case, it is going to put all those evidences in the favor and against in the database. And database is going to check in such cases what kind of the judgment was given earlier, and on that basis it will also deliver the judgment. Is it right or is it wrong? It is right or it is wrong. Public is not speaking because public know that if I speak, I have to provide the reason. Not speaking means you agree with that. Wrong. Why it is wrong? Do you know that there is an image in the court? Fine. The lady justice. Fine. And her eyes are closed. Why? Because she should not be emotional while delivering the judgment. So court should not be emotional. Court should not be emotional while delivering the judgment. And AI is brutal, working on algorithms. Like a kid who is crying loudly, it doesn't matter, do you have money or not? They do not understand. They are crying outside a shop and they want to purchase a toy. It doesn't matter for them whether they know that you do not have a money or what. They are crying. Their objective is to get that toy of their choice. Fine. They do not consider your emotion. If they are toddlers, fine, whatever. So emotions is not something which is a reason. Fine. See, when the judgment is being given on the basis of certain circumstances, and sometimes circumstances change, and according to the circumstances and situation, Supreme Court also, any court, not Supreme Court, they can also change their judgment, and AI is not able to analyze and understand the circumstances in the human's way. So a judgment do not involve emotions, but judgment involves emotional intelligence. So emotional intelligence is required while writing the judgment. Fine. Social customs need to be known. Multiple factors need to be known. Fine. So this is not a capability of artificial intelligence, and if AI is going to do that thing, it will create a disaster. So we should not use AI at all. Again, answer is no. AI is very helpful for back office operation. So like any other back office operation in the world, they are using and integrating AI. Courts can also think about integration of the AI in the non-judicial matter of the court. But in the judicial matter of the court, it should not be used. So, Supreme Court have found that in multiple instances where the AI is being unnecessarily used. But when Supreme Court shows a concern, certain group of lawyers also said that if you will completely reject the AI, it is also not true. Then Supreme Court have appointed a committee, and that committee have recently released the report. In that report, they have put a draft and they have asked the public opinion on that. And public can give an opinion till then 20th of June. Once the public window is being closed, Supreme Court is going to again see the draft, and then Supreme Court will release final guidelines with respect to use of AI in the courts. Fine. So in that context, I have mentioned algorithmic justice because court is basically concerned algorithmic justice should not be used in the court. Algorithmic justice means, have you understood what is algorithmic justice? So please write. Algorithmic justice is basically justice delivered through automated algorithms. Algorithmic justice, AJ, algorithmic justice is basically justice delivered through automated algorithms. Automated algorithms instead of human judge's mind. Instead of human judge's mind. Now write. Next point. Supreme Court's Artificial Intelligence Committee. Supreme Court's Artificial Intelligence Committee has released draft regulations. Has released a draft regulations on use of AI. On use of AI in justice system. Use of AI in justice, in space justice, not right injustice, in space justice. Fine. Otherwise, you write injustice system. In justice system, open for public feedback, though it's not required. Don't write this because by the time you are going to revise, date will be over. So this point is important because this is a rollover news. So 20th of June, public will submit. Then again Supreme Court will come with the final guideline. So you have to keep this news because it's a rollover news. This will again appear in the leading newspaper, and of course articles will be also written by the leading newspaper whether it is right or whether it is wrong. Fine. So this information, write one more thing. The stated aim of Supreme Court committee is write in the inverted commas. AI can assist courts. AI can assist courts in administration and in research. Administration and in research, but cannot replace human judicial mind. Human judicial mind. Fine. Now write a question and try to attempt this question. Fine. Discuss the constitutional and ethical concerns. Discuss the constitutional and ethical concerns that led Supreme Court that led Supreme Court to bar algorithmic justice. To bar algorithmic justice and restrict AI to an assistive role in the courts and restrict AI to an assistive role in the courts. Fine. So try to attempt this question. Model answer I'll provide. Model answer I'll provide. Algorithmic justice I have already mentioned. Fine. Now try to explore the various dimensions of this question, algorithmic justice, and see, to write this answer, you have to present certain cases. So you have to do a search, what cases have led to Supreme Court to look in this matter. Fine. What are the issues associated with the algorithmic justice? So to write this answer, you have to gather these two data. Which cases led to the Supreme Court to do this, and what are the harms created by algorithmic justice, but why AI should not be completely off the table. Why AI should be used in the matter of administration, in the matter of research in the judicial system. So judicial administration and judicial research, you can use what? Artificial intelligence, but it should not replace whom? Human judge's mind. So this answer need to be meticulously written. Those people who are having the issue, you are asking me on that day, discuss and all the types of the question. I have discussed in yesterday's session. So in the yesterday's session regarding how to write an answer. Fine. In the morning, I have taken one session, how to write an answer, that is for beginner. Fine. Though it is for the beginner, but I have discussed how to approach critical evaluation, examination. Fine. All these things I have discussed in yesterday's YouTube session, which is available in the YouTube. If you are having the issue, how to tackle such questions, discuss, examine, fine, or critical evaluation, analysis, fine, to what extent this is right or wrong. Such 6 types of the question which is being framed by the UPSC in the general studies question paper. I have dealt with all 6 types of the cases. It will be very helpful for you if you are looking to tackle such way. So I have taken the beginners, but as we are going to progress in the answer writing, again we will take a session how to make your answer better. So that session was focused basically on how to frame your answer. Framing on the answer. Then I also have discussed in today's session, in the morning, I have discussed how to tackle paper 1, paper 2, paper 3 and paper 4. Again, for those who starting their preparation. Fine. Then in next few months, we are in the month of June. By the next month, means July, August, I will again take the case how to expedite and how to enrich your answer writing process. Fine. How to go for data enrichment. In what way it need to be tackled. So time to time we are going to have this. So please start writing your answers. You are in the June, July, August, September. You have to gain the momentum for answer writing practice. Once the momentum is being gained, then from September, October, November and December, these months are qualitative improvement. First 4 months are going to be focused on framework consolidation. How to write an answer. How to write an answer, that need to be focused in first 4 months. Give your time. Have patience. Don't be in the hurry. Focus on that aspect. Once you have consolidated your framing of the answer, then the qualitative improvement is required in next 4 or 5 months, and that will go again and again. Fine? In this way will go. One more news you have to write regarding 𝐕𝐵-𝐺𝐸𝐺. Fine? Right. Give a heading. 𝐕𝐵-𝐺𝐸𝐺 draft rule released. 𝐕𝐵-𝐺𝐸𝐺 draft rule released. Right. Ministry of Rural Development has released draft rules. For Viksit Bharat guarantee for Rozgar and Ajivika Mission. Rozgar and Ajivika Mission in brackets Grameen. Rozgar and Ajivika Mission Grameen, which replaced MG Narega. Which replaced MG Narega. Which will replace MG Narega from 1st July 2026. Fine. Now, what you have to do, make a table, features, then VB, 𝐃𝐸𝐺𝐰𝐵, then MG Narega. Fine? Right. Under features, first is employment guaranteed or guaranteed employment. First feature is guaranteed employment. VB 𝐃𝐸𝐺𝐰𝐵 125 days per year. VB 𝐃𝐸𝐺𝐰𝐵 offers 125 days per year. MG Narega 100 days per year. 100 days per year. Next feature is funding model. Next feature is funding model. VB 𝐃𝐸𝐺𝐰𝐵 60/40. VB 𝐃𝐸𝐺𝐰𝐵 60/40. 60/40 and the same and 90/10. 60/40 and 90/10. After 90/10 means 90:10. Fine? 90:10. This 90:10 for which one? Northeastern states. Better to write hilly states. Fine? Hilly states and UTs. Hilly states and UTs, Union Territories. Hilly states and UTs. And for remaining 60/40. For remaining 60/40. This system makes this scheme VB 𝐃𝐸𝐺𝐰𝐵 is actually what? It is now central sponsored schemes. This is centrally sponsored schemes. Central sponsor. MG Narega was central sector schemes. And right in the MG Narega, 100% by central government. 100% by central government. So those students who do not have an idea what is central sector scheme and centrally sponsored scheme. Central sector scheme means 100% by whom? Government of India. 100% by Government of India. In which scheme? Central sector scheme. Centrally sponsored schemes, usually something need to be paid by whom? States. And this is why states are not happy. In the earlier scheme, they need not to contribute anything. But now they have to contribute in the scheme. Third point, wage payment. Wage payment. Direct to account. Under direct benefit transfer. Direct to account under DBT. That was same in Manrega also. This one is important and interesting also. Sowing season pause. SOWING. Sowing season pause. Sowing season pause. 60 days no work period. 60 days no work period during peak farm season. 60 days no work period during peak farm season. So usually when the sowing season is there, more and more laborers are required. And these laborers are not available because they are involved in which work? MG Narega related work. But now there is no such provision under VB 𝐃𝐸𝐺𝐰𝐵. There will be pause of MG Narega work like VB 𝐃𝐸𝐺𝐰𝐵 work. So VB 𝐃𝐸𝐺 work is going to be paused during the sowing season so that labor availability will be easy for the sowing purpose and the agriculture purpose. Fine. Right, one more point. Have you understood this point? Clear? Right, next point. Wage rate. Wage rate. No, MJ Narega was not having any pause. In the MJ Narega, there is no such pause. MJ Narega was not having pause. Only 𝐵𝐵 𝐺𝐸 have this pause. So mention there, if you have not mentioned, under the sowing season, pause. 60 days pause, you have mentioned at where? 𝐵𝐵 𝐺𝐸. No pause in the MJ Narega. No pause. Fine. Wage rate. Wages will be paid 240 rupees per day. 𝐵𝐵 𝐺𝐸 240 rupees per day. In MJ Narega, 205 rupees per day. Fine. Now, one more. Governance body. Governance body. Next feature is governance body. National level steering committee. National level steering, STEERING, steering committee. And national level steering committee and Central Gramin Rozgar Guarantee Council. National level steering committee and Central Gramin Rozgar Guarantee Council. No such provision was in Manrega. No such provisions was there in the Manrega. Fine. So those are key features. But I have created a detailed document, 𝐵𝐵 𝐺𝐸 versus MJ Narega, which has been sent to all of you. I hope everyone have got. Anyone who have not received in the WhatsApp group? It is being given to all WhatsApp group. Fine. So you can refer to that file. In that file, I have discussed in the detail. 𝐵𝐵 𝐺𝐸. Those who are watching in the online, they have not access. Once this session will be uploaded in the YouTube after live session, I will ask them, they will attach there. Fine. So you'll get it from there. Next scheme, right? One more scheme. Pradhan Mantri, it's a different scheme. Pradhan Mantri Surakshit Matritva 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 Abhiyan. Pradhanmantri Surakshit Matritva Abhiyan. Fine. In short, PMSMA. PMSMA. Though this scheme is not usually in the news, but this scheme has completed 10 years. Fine. So 10 years is being completed by the scheme. And usually such news we are not able to pick. And UPSC will pick. And then people will shout, what nonsense is this? Why you can ask, there are 300, 400 random schemes and question can be framed from any random scheme. How I am able to read all 300, 400 schemes? So, they are not randomly picking. They are picking precisely. For example, this scheme has completed 10 years. Fine. So this is why they are going to pick. UPSC is not an idiot. Those who are calling UPSC idiot, they are idiot actually. So do not fall. See, when we are not able to correct the question, we are not able to attempt the question, we have anger with respect to UPSC. That is quite natural. हमने भी खूब गालियां दी हैं, ठीक है, और वहां जाके दी है, ठीक है. Though it was closed, fine, and we like कि यार क्या है तुम लोग, क्या नाटकी करके रखा है? What nonsense you people are doing? So we have this enraged. Even when we are the student, we have this enraged with respect to the UPSC. But gradually we will able to understand that UPSC is a highly rational organization, and considering itself as an irrational organization only harm to us. Consider your opponent never weak, irrational. Consider your opponent with whom you are going to tackle, it's strong, clever and sharp. Then you will uplift your skill in order to tackle. If you will consider irrational, you are just trying to create an excuse for your non-performance. So when we say that, "Arey, wo to irrational hai, they are irrational, they are idiot," all these things, You are just trying to create an excuse. When you are not going to perform, you can give the excuse that they are non-performing, or they are bad, or they are this or that. So such things are not required. Focus on the way. So UPSC always focus on the certain things which are relevant with the present time. Okay? So 10 years being completed, few features you have to write. In the subheading, you can write in the subheading, number 1, fixed day, fixed package. Fixed day, fixed package. Services are provided on a specific day. Specific day, every month. Every month, usually on 9th of each month. 9th of each month. These services are focused towards primarily towards pregnant women. Next, this scheme includes minimum service package. Minimum service package which includes clinical examination, blood pressure, weight monitoring, anemia screening, anemia screening, blood and urine test, immunization, and counseling on diet. It is implemented across states. Through National Health Mission. The core objective of the mission is to decrease MMR. Mother mortality rate. Decrease MMR. Fine. Now, give a subheading. How to use this in the answer. How to use this information in the answer. Point number 1. In GS2, you can integrate health and welfare scheme. Health and welfare of whom? Women. So, women health and care you can use. In GS3, you can use in the human development, especially SDG 3.1. SDG 3.1, which focuses on, SDG stand for Sustainable Development Goals. SDG stand for Sustainable Development Goals 3.3 and 3.1 means Sustainable Development Goal number 3 have multiple points, and the first point is to decrease mother mortality rate. Fine. So SDG 3.1 in brackets, mother or maternal mortality. Mother mortality rate or maternal mortality. Fine. and you can also integrate in essay. While writing essay, you can add as an evidence of targeted fixed day delivery, fixed day service delivery. Targeted and fixed day service delivery. Why fixed day? Because it is being provided every 9th of each month. So each month on 9th, this service is being given. Was you aware of this scheme? Was you aware of the scheme? So this is why, see, sometimes even if you are not able to pinpoint, but once you understand the importance of the scheme, because see, for a pregnant woman, especially belongs to very weak income group or very lower income group, usually such things are being ignored. Why? Because they are costly and local people, they are going to support, no, not required. But these things sometimes become fatal. Fine. A very, one of the baddest thing I have seen in my life. Fine. We are doing our preparation and we are in the area where we are living. Next to that house, one pregnant lady was there. Fine. And she was pregnant by 7 months. She died. Fine. She died. And when they put the body of the woman outside, you can see the crawling of the baby in her belly. आप देख सकते हो. So that was very unfortunate. Fine. Very unfortunate. People are even not able to take her to the hospital. She died. Now the baby is also going to die. Fine. So knowledge nahi hai logon ko. Many people said that you can take the hospital. Fine. So sometimes the unawareness, and she died because of what? She died because of no proper treatment. They are consulting some local people only, rather than going for proper medical advice. So this is the worst thing I have seen in my life. Fine. But this is not something which is only occurred once. It is very common thing, usually happen in the rural as well as in the urban area, especially in the slum areas or low income area. But with this facility, now a free of cost facility available at local health center where women can go for routine test. Even the ultrasound is required, they will do that. All these tests. So basically, you can be aware of your health and it can save the precious human life. So this is a very important scheme, though it is not look like very important for us, but it is very important for those people who are not able to afford even 100 rupees test. Fine. But this scheme can save their life. Okay. So sometimes a scheme need not to be economically important. How it is going to impact the bottom tier of the society. So do not consider only those schemes are important which are hitting the national economy or they are going to work at very big level. Certain schemes which are at there for the bottom level of the population, they are also important and they are actually most important for UPSC exam. Paper 1, Indian society. You can target there. Fine. Social part. Paper 2, you can target governance. Paper 3, you can target human development. So remember that all bottom tier schemes. एक बार try करना ये prompt डालकर, do this prompt in the chat GPT and ask कि I want to know what are the specialized scheme of the government of India for people below poverty line, and I am not interested only in the monetary benefits, all other benefits based scheme of the government of India for economically weaker section, not UPSC or EWS. Fine. Those people who are below poverty line. So those people who are the below poverty line in India, what kind of the facilities provided by the government to include them in the mainstream society, or you can write it this way, for their health, for their economic benefits, for their employment generation purpose, what schemes are there? Okay? Just do this prompting and see the magic. Fine. So these things are for this session. Fine, which I feel that important, though there are certain other topics. Fine, for example, FCNR, which I will take in between and I will upload the video so that you will get it. Fine, FCNR issue is also there, but it needs proper explanation of half an hour. So I will take one session on coming Tuesday and I will upload it for you. So keep an eye on the videos which we are going to upload. Not for likes and subscribe, but for your better future. Okay? So we are going to upload consistently video. So my promise for you is June 1st to June 15th, all important current affairs in one file. Model answer and certain things other I have promised I will provide you in the PDF file. Your job is what? Your job is to compile it and put in the library. No, your job is to read and revise. Any current affairs material at least need to be revised 3 to 4 times before the exam. Otherwise, it is not going to work for you. 3 to 4 revision are required. Okay? So see you in the next class. Thank you.